Good evening and welcome to this session of the virtual coaching classes organized by the Board of Studies of the Institute of Chartered Accountants of India. We are in the process of discussing the topic incorporation of a company and matters incidental thereto. In fact, we've finished the concept of incorporation, one-person companies, Section 8, companies licensed to operate under Section 8, so-called non-profit organizations, non-profit companies, etc., etc. We also went in depth into the memorandum and articles. We saw what they are, right? We saw what they are, the various clauses of the memorandum, and the meaning of each clause. Now, later on today, we will be going in depth into the name clause, the domicile clause, etc. Also, how to alter them. See, when the company is incorporated, it starts with a particular name. It may want to change that name. Sometimes it may have to change that name compulsorily. I'll tell you when. So all that we'll discuss. Also, we'll talk about domicile or situation clause, changing. We will not just talk about changing the situation clause, which is only one aspect, but we will talk about registered office itself and how to change the registered office and procedure. Some of it would be procedural, okay? You should understand that the Companies Act is a procedural law. So there is a lot of form filing and a lot of, uploading of stuff and things like that, which basically you and I as chartered accountants are not, we are not supposed to do that because we have a sister profession, the Institute of Company Secretaries of India, which has got people called company secretaries who actually have to do this. They are better at it than us. In terms of, it's better they do it than us. But then, just as you know, I always compare us to a surgeon or a MS or an MD, when it's not as if this guy wouldn't know about anesthetics or wouldn't know about pharmacology. So it's good to know all that. So yes, you are going to specialize. You're going to be one of the top in the finance field. But still, it's good to know these things so that you could advise the client broadly on everything. When you are giving a client, a total solution, my dear friends, it would involve taxation, both direct and indirect, strategy, company law, of course, security laws, which is why your knowledge should be broad-based. You cannot simply talk from one perspective and say, I don't know the rest, which is why you need to know a little bit about these things. So I'm going to teach you, or shall we say it is my privilege to teach you this particular subject, company law. So there's a lot of procedure here, forms, etc. Okay, from an exam perspective, should I remember form numbers? Yes, you should. Okay, what form numbers should I remember? Those form numbers which are there in the institute material, which will also be in my notes or slides or whatever you call them. Okay, before somebody puts a query, immediately I answer, you will not get these slides now, you will get it on Saturday. Okay, again, before somebody puts it, sir, when can I have the slide? You will get it, but only on Saturday. I'm very strict on this. I'm not going to change my policy. Okay. In the meantime, if you want to prepare, if you're so eager to be thorough in this topic, no problem. Read the material once more and keep yourself prepared. Don't worry. My notes will be with you well in time for you to prepare for your examination. Wonderful. Moving on. A little bit about the name class. We spoke about the reservation of name, etc., etc. We also saw articles. We also saw that the articles, some provisions of the articles can be entrenched. That means the company can make it more difficult for these provisions to be amended. There could be something that is very important. So they could say, amending this will require a higher majority than even a special resolution, more restrictive than those applicable in the case of a special resolution. As I already mentioned to you, there are two types of resolutions, so-called ordinary resolution, which is basically a simple majority, and Okay. So I can see some of my old students. For example, Siddharth Mudaliar already sent a message on WhatsApp, and now Poojaji is sending a message here. Because see, Jai Shri Krishna, because of Krishna. Okay, Sarva Dharman Paridhyajya Maam Ekam Saranam Braja Aham Tva Sarva Papebhyo Mokshekshami Masucha. Everything is with him. Ananyan Chindayanto Maam Yajana Fanibasate Tesham Nithyabi Yuktanam Yoga Kshemam Ahamyaham. So this is the promise given that God has given to us, that if you only sincerely work, okay, God will take care of the result. Do not keep worrying about what will happen. So wishing all the best for costing exam also to all of you who are writing. For those of you who are going to write, the current students, okay, this is becoming a real challenge. A lot of old students are coming in and putting up messages. Yeah. Rajiv Sharma is of the view that it's good to end it earlier by not taking a break. Gee, I'm also happy with it. Maybe we'll try it today. Also, it will help even for me to do that. I would love to do that. Let us see. Maybe we can go till 8:20 or so and then close it. Right? No problem. Okay. So, yeah, don't worry. You read everything from the institute material. Just mark items which you don't know and all. You can ask me in the query pad also. And more importantly, when the notes come, when I upload it, it will become a double revision for you. And then before the exam, you need not read the entire material again. It is enough if you just go through my PowerPoint presentations. Said 1 week before the exam, you only go through my PowerPoint presentations and questions. You will find the power is very different. Anyway, good show. So moving on. If there is provision in the articles or memorandum, right, which is contrary to the Companies Act 2013, the Act will prevail. There cannot be anything in the articles or memorandum of a company which is repugnant or unacceptable to the provisions of the Act. If such provisions are there, those provisions will be void or become void. Once they become void, what will happen? They'll become a nullity in law. Nobody can enforce it. Neither the company nor the outsider, third party can enforce it. So, and this is notwithstanding anything. The Act will always prevail. Act is superior to memorandum and articles. You might want to remember this, right? But then remember, this particular section 6 begins with the words save as otherwise provided, which means there is a section in the Act which says articles can provide differently, then such provision will be applicable. Example given is 47. Section 47 is applicable to a private company subject to articles of association. So if the articles of association of a private company says that section 47 is not applicable, then the articles of association will become superior. Why? Because the section says, in spite of if the articles provide otherwise, that will apply. So that save as otherwise provided in this Act, save as provided in this Act, expressly provided. So actually there are many sections in the Act where they specifically say articles can provide otherwise. If they do that, and if the articles are providing differently, then articles will prevail rather than Act. So the Act will give permission. So sometimes they'll say, you do what you want. For example, in the final syllabus, you will see additional director, appointment of additional director. There the Act itself says very clearly, the articles of association may provide. If so, without derogation to what is provided in the articles and subject to the articles. But in case the articles are silent, then this section will apply. If the articles mention, then the article will prevail. So, but for that there should be a specific express provision in the Act. Express means in writing, clear, in words. That is called express. Implied, opposite of express is implied. Implied means something that is not written or oral or verbal. It is understood from the situation. It is circumstances, etc. Implied like that. Okay. So, see, suppose I am sitting inside a room. You are standing outside near the door and you are asking me, you want to give something to me. You are asking me, sir, shall I give you this item? I am saying, yes, please give it. That means what? Should I give you special permission for entering the room? Why? Because it is implied. Since I am inside the room and you are outside, you are having something you want to give to me. I am permitting you to give it to me. I don't have to also say, come inside and give it to me. Come inside is implied in the transaction. Whereas come and give it to me is expressed. Inside, come inside is implied because you cannot give it to me unless you come inside. Got it? I know it sounds a little confusing, but this is logic of law. Okay? You have to always, some things are implied in that. If you say that I can do that, then it is implied that I can do this. Correct? Wonderful. We already saw that the memorandum and articles of association constitute a binding contract between company and members and company, and also members inter se. Members inter se means amongst each other or between themselves. Okay, so can you see the triangular way? Member to company, company to member, and each member to member. Everybody is bound by the memorandum and articles. So memorandum and articles are basically contract. Okay. Your basic contract act. Contract act is what? Consensus ad item. Okay. People have to come together. That is done in the memorandum subscription clause. The subscription clause of the memorandum says we the several persons agree. That is why it becomes a contract. To be formed as a company. Once the signatories sign it, they now enter into a contract. When they sign the memorandum, by a moment of magic, by the law, the magic of law, a new person comes in. Imagine, no? So we are doing some yajna, and then from the fire of that yajna, a new being is coming. That is what happens when you incorporate a company. 7 people sign the memorandum, suddenly one new entity comes. That is called the company. Now, a contract is being entered into between this new being and these 7 people, and also between each other. This is the legal implication of signing the memorandum and getting it registered. The minute the registrar of companies incorporates the company, a new being comes. And at that point in time, there is a contract. The new being is entering into a contract with every member. Every member is bound to the new being called the company, and every member is bound to each other. So the memorandum and articles are a contract. And now think about it. When one member is leaving, what is happening? He is quitting the contract. Similarly, when a new member comes, what is happening? He is joining the contract. That is why whenever shares are transferred, you have to inform the company. I will talk more about it possibly when we come to share capital. But point is, this contract needs to be entered into. Whenever a person applies in writing to become a member of a company, he is making the offer. When the shares are allotted by the board, the offer is accepted contract. Not between him and the company, company and him and every other member. So every new member also enters into the contract. When a member sells the share and goes off, he walks away from the contract. Okay, this is an underlying legal principle. It will be good if you know it. If you know this, your knowledge of company law will be more in-depth rather than casual. Okay, so the MOA and AOA create a contract between the company and its members, and the members inter se. But there is no privity of contract for non-members. Okay, here's the story. Thank you. Here's the story of Eley. I'm sorry. You see, this is a small pictorial pun. I don't know how many of you will understand the pictorial pun that I have put here. Because the case law is Eley versus Positive Government Security Life Assurance Company. Eley is the name of a person, right? But in Tamil Nadu, Eley is actually mouse. So I have put a mouse picture here. Okay. So Eley is mouse in Tamil Nadu. So this is a pictorial pun. So what did this Eley do? Let us see. The articles of a company provided that Eley should be a solicitor for life to the company and should not be removed from office except for misconduct. Where is it contained? In the articles. Articles is the contract between who? Between members and company and members inter se. Who is Eley? Nobody. Important point. Eley is not a member. Even if he is a member, he is only bound as a member. It so happens later on this fellow Eley also became a member of the company. But after employing him as a solicitor for a number of years, the company discontinued his services. Now Eley came out and said, hey, look here, as per the articles, you cannot remove me except for misconduct. How can you remove me? So he, being a member, sued the company for damages for breach of contract contained in the articles. Now, will this case be heard? Will the court accept this view? No. Why? His case was dismissed. Because, see, yes, Eley's right was affected, but not as a member, but as a solicitor. He has the right, but what was affected was not his right as a member, but his right as a solicitor. As a solicitor, he is a third party. He is not a party to the articles. In Latin, we say he has no locus standi. See, suppose I have A and B have a contract. Can C come and sue? No, because the contract is between A and B. C is the third party. He has no locus, L-O-C-U-S, locus standi, S-T-A-N-D-I-I. No position, no authority to sue because he is not a party. He has no locus. Okay? Eley has no locus. Right? Because there should have been a contract separately between the newly formed company and Eley for appointing him as a solicitor for life, blah, blah. It was mentioned in the articles. Independent of the articles, there is no contract. In the absence of such a contract, separately with Mr. Eley, he cannot sue as a member enforcing the contract for appointing him as a solicitor. Okay? There is a distinction which you must understand. Eley has two rights. Right as a solicitor, third party, right as a member. As a member, if he has any problem, he can sue. For example, if he does not get dividend or if he does not get the piece of meeting, etc., he can sue. That is his right as a member. Here, his right as a solicitor has been violated. It so happens the articles speak about appointment for life. But as far as that is concerned, Eley is a third party. He cannot sue. There was no infringement of his right as a member. Therefore, he cannot sue. This is Eley versus Positive Government Security Life Assurance Company. There's an ulta case. You might want to see the other option. When the company and member are bound, see, think about it. The articles of a company contained a clause that on the bankruptcy, the bankruptcy of a member, bankruptcy means insolvency. Bankrupt, insolvency means his assets are unable to meet the liabilities. Bankrupt. So, there is a person who is a member of a company. Now, the articles of the company says on the bankruptcy, insolvency of a member, his shares should be sold to the other shareholders at a fixed price by the directors. See, what happens? That money will be used for paying his creditors. But the articles say, in case the member becomes bankrupt, his shares should not be sold to a third party. It should be sold to the other shareholders at a price fixed by the directors. Now, B, Borland. For example, that name is Borland. Borland's trustee. Borland, a shareholder, was adjudicated bankrupt. He was declared to be insolvent. The court has passed an order that his assets are not enough to pay his liability. One of the assets is his share in this company, correct? One of those assets is his share. Now the director said, hey, as per the articles, one of the shareholder will buy, this is the price. Now the trustee, he is similar to the liquidator or assignee. Once B becomes bankrupt, the trustee will take over the assets. He will sell them and pay the liabilities and report to the court. In England, he is called a trustee. In India, we call him assignee or receiver. In India, we call this person assignee or receiver. Once a person becomes insolvent, individual becomes insolvent, the assignee will come. In case the company becomes insolvent, the resolution professional will take over. Whoever it is, that person will then be in charge of the company. So this trustee in bankruptcy, he claimed that he was not bound by these provisions because he is only the trustee. See, he used the logic of Eley in a reverse way. He said, look here, articles is between you guys. I am the trustee. I am not bound by it. I am third party. And I will sell it to anybody at the correct value. But then the court said, sorry, the trustee is only representing the estate of B, Borland. The trustee is not independent. He is not a third party. Basically, B is the shareholder who signed the original articles. So B is bound means his legal representatives like trustee, etc., are also bound. So the trustee was bound by the articles as the share was purchased by B upon the terms mentioned in the articles. Okay. See, every day if you tell internet connection, this is my best connection. I'm not able to do anything about it. So please don't give that complaint. If you are, maybe that's a bad for me that this is the best internet connection I can give you. I have no better internet connection than this, right? So kindly bear with me. Yesterday, some people said it was not there. Then some people said it is coming. So don't disturb the class with internet related issues. Only if the institute tech people tell me, I will do. Otherwise also nothing can be done. This is the best internet connection that I have. Got it? I can't do anything about it. Beyond this, I cannot improve my internet connection. Okay. So if there is any problem, just aram se bear with it. It will become all right. Okay. It will be from my end only. Assuming it's from my end also, I cannot do anything. Okay. Sorry for being so blunt. Because what can I do? Our time is only wasted by these. If I keep looking at it, doing something, it becomes a problem. See, solicitor is nothing but advocate. Lawyer. In England, there are different types of lawyers. Advocates and barristers, they argue in the courts. Whereas solicitors will not argue in the court. They will only advise clients and they will brief the advocate. So solicitors will be legal advisors and they will run trust funds and all that. Whereas the lawyers, they are called advocates, barristers. They will appear in court and argue. There is small difference. In India, we don't have that distinction. We use the word solicitor, lawyer, advocate, barrister, everything similar. Okay. Yes, absolutely correct. Company is liable only to its members under the memorandum and articles. Similarly, members are liable to the company for whatever they are owing, whatever they agree, they have to do it. Okay, beautiful. Moving on. So, solicitor, in this case, Eley is a legal advisor. Solicitor, he is an advocate. Eley is an advocate, also a solicitor. He will not appear in court. He will only be advising companies and on legal issues. Legal advisor. Okay. Now, we are moving on to another important topic called doctrines. We already saw one doctrine earlier, which was called the doctrine of constructive notice. The doctrine of constructive notice. What is that doctrine? It means any document. One second. Yeah. First, you have to understand doctrine of constructive notice. We already saw it earlier when we spoke about incorporation. We said in incorporation, I said once any document is uploaded in the NCA website, it becomes a public document. It becomes a public document. Such a public document can be viewed or seen by anybody. We also discussed about that. There is a payment for downloading, but for viewing, there is no payment, etc. So you can, any document, not only the memorandum articles, etc., any document, even charges which are registered, later you will see that everything becomes a public document. Therefore, any person who wants to have a dealing with the company should visit the MCA website and view the company's data. If necessary, he should pay money, download the data and have a better look. No problem. If he does that, he is intelligent, because then he will know about that company. But suppose he does not know, he does not see it at all, still he is bound. It is deemed, it is presumed that he has read it. Not only read it, that he has understood it. That is why this doctrine is called Doctrine of Constructive Notice. Constructive means deemed. Deemed, another word, presumed. See, I am deemed to be a person, something means, that means I may not be that. Still I am deemed to be. Once you say deemed, you are creating what is known as a legal fiction. You are creating legal fiction. That is why in income tax we have something called deemed dividend. A company in which public are not substantially interested is giving a loan to a director. But they say, to the extent of the accumulated profits, the loan is deemed to be dividend. That means what? Even though it is a loan, it is presumed to be dividend and taxed as income. Definition of income, 222E. So the point I'm trying to make here is, deemed is a very powerful word. Once you see deemed there, it means that you cannot talk logic. They are countering logic and saying, we are saying this is that, presumed. So here they are saying, knowledge is presumed. Even if you have not read the memorandum, even if you have not read the articles, the third party is presumed, okay, to have read it. So this is called constructive. This is a rule of presumption, that a third party proposing to deal with the company has read all the documents filed with the ROC. Also that he has understood them. That is also implied. That not only has he read there, he has understood them. Therefore, he is expected to know what the company can and cannot do. He cannot later plead ignorance. For example, in this case, tomorrow say that the provision was there in the articles, man. No, because when he became a member, it is deemed that he would have read the articles containing the clause. Are you able to understand? Even B cannot say, even though he has not read the articles, if he becomes a member, then he is deemed to have read it. Third parties who have dealings with the company are deemed to have read the memorandum and articles. Therefore, they are expected to know what the company can and cannot do. He cannot later plead ignorance. Later on, he cannot come and say, sorry, I am not aware of it. You are deemed to be aware. Okay? Yes. Matanjali gives us a view. Let us see what it is. Doctrine of constructive notice protects company against outsiders, and it says that MOA is a public document. It's not meant only to protect the company against the third party. Okay, it is meant to ensure that third parties tomorrow cannot say, I'm not aware. Yeah, to an extent, it protects the company against the third parties. My God. I'm just changing my connection and seeing. Let us see if this is better. I'm having two connections here. I'm struggling. Okay. Now, after we have seen doctrine of constructive notice, and Matanjali has also given us a nice view regarding that, I will go to doctrine of ultra vires. So, doctrine of ultra vires says ultra means beyond, vires means powers. It's a Latin term. This term is a Latin term. When you are studying law, you will come across Latin terms. Suggestion, keep a notebook or keep in the last page of your notes, keep writing down all the Latin terms that you're coming across. Whenever you come across a new Latin term in these topics or in law, income tax, wherever some faculty uses a Latin term and explains it, then write it down. You should become familiar with these Latin terms. Why Latin? Because Latin was the legal language in Britain. How did Latin? Latin is the language of the ancient Romans. Even Latin is not spoken in Italy now. Italians speak Italian, okay, which is different from Latin. Though, of course, it's similar, but Latin is far more. In fact, Latin, Greek, Sanskrit, they are all related languages. You'll find that they have commonalities. They seem to have had a common origin language somewhere. We don't know where. One origin language is there for all these languages. Now, what happened is English evolved from Latin. Just for their information, the Britain was originally not, there were no Britons, first of all. Okay, you had some aboriginal people there. They were called the ancient Britons. That's why we call Adivasis and all. They were called ancient Britons. Literally, they were forest people, okay, primitives. Now then what happened when these people were ruling in Britain, they were sort of there, Rome came. The Romans conquered Britain and they civilized it. And throughout the Roman Empire, Rome sort of influenced Britain. And at one point in time, Rome became weak and England started getting its own kings. The Vikings invaded Britain and they also came. Then what happened is the Germanic Vikings became the Saxons. And some of the original Roman Latinized people went out to France. And then they came back with William the Conqueror. And for a long time, French was spoken in England. French was spoken in Britain. Right up to Richard II, Henry II and all, it was French. Okay. Then slowly the language that we call English evolved. It was an amalgamated language. I'm sorry for giving this unnecessary philological lecture. Philology is the study of languages, but then it's nice to know this, that English itself is not an original language. Unlike Sanskrit or Tamil, English is not an original language. It is an evolved language. It evolved from German, not even German, Scandinavian. It evolved from Nordic. It evolved from Latin. It evolved from Latin, in turn, sort of French came out and French. So English is an amalgamate, which means so many words in English have their roots in Latin or French words or Germanic words, Scandinavian words. If you know them, your knowledge of English will become better. So here, and when the Romans conquered England, the British started speaking Latin. Latin was the language. Then when English started evolving, okay, it became like the good old Pali. For a long time in India, Sanskrit was the court language. Pali was the common man's language. Then over a period of time, Pali evolved, joined with Urdu, joined with other languages and became what we now call Hindi. The language that we now call Hindi and speak is a sort of an amalgamated derivative from Pali, which then got merged with, every invader who came in added to Hindi. They increased the vocabulary in Hindi, including the British, so on and so forth, which means the Hindi became, the English is like that. It's a very vibrant language, which is why Hindi survives for so long, because it's vibrant, it's dynamic, it picks up new words. It doesn't become steady. It doesn't say I won't change. Unlike Tamil or Sanskrit, Hindi does not say I will not change. Okay. Anyway, sorry for this unnecessarily elaborate lecture on language. But the point is, if you want to know law better, you should be familiar with Latin terms. Because Britain, even after the Romans went away, Britishers continued to use Latin as the court language. So in court, for a long time, British courts, Latin was spoken. The judgments were in Latin. And the priests, the Catholic priests, they were experts in Latin. In India, after the British conquered India, Latin was, people used to learn Latin, including Mahatma Gandhi in his experiments with truth. He says when he went to England, he had to learn Latin, which was very difficult, he says. Anyway, then he wanted to become a lawyer, then he should learn Latin. So ultra vires literally means beyond the powers. The opposite term is intra vires, which means within powers. So in future, when we use the words ultra vires, remember beyond the powers. intra vires within the powers. So we will use sentences like, what has been done is intra vires the company, but ultra vires the directors. What does it mean? It is within the powers of the company, but outside the powers of the directors. Ultra vires the powers of the directors. Ultra vires the directors, intra vires the company, like that. But there are certain things which are ultra vires the company itself. It is beyond the powers of the company to do. So, when a company or its directors violate the provisions of this act or any other law, such an act is unlawful and attracts a penal liability. The act cannot be ratified even with the consent of all the members. Right? But if it's illegal, company cannot ratify. But if it is legal and it is something that the company can do, but the directors have exceeded their authority, then the company may ratify. See, let us say that there is a provision in the articles which says property of the company cannot be sold by the directors. Resolution of the members is needed. Property of the directors cannot be sold by directors. Resolution of the company means members have to pass a resolution. The directors sell the property at a good profit without passing the resolution. Clearly, they have exceeded their powers. They cannot sell now without the permission of the member, but they have done it. Act is over. Third party has got the property, company has got the money. And the profit is there. Now the members may meet and they may say, Chalo, what has happened is wrong, but we are happy with what you did. We ratify. Ratify means after the mistake has happened, we will permit it or we will pardon it. You did something wrong, what you did should. But then this is something that the company itself can do. Selling the property is within the powers of the company. The directors have sold it without the company's permission in the resolution. But the company can ratify. But if the act is something even the company cannot do, ratify means to pardon after something has been done wrongly. Or, see, you are asking me to do something, you are giving me some conditions, I am violating the condition. Later on you feel, Chalo, even though you have violated, I will ratify, permit. Similarly, in agency later on you will study, in Contract Act, agency by ratification. That is, the principal has given conditions to the agent, what to do with the goods. The agent in his own initiative has done something which is beyond his powers, ultra vires the agent. Then the principal comes and looks at it and feels, okay, what you did is not correct, you shouldn't do it. Without my permission, you did it, but what you did is good only. Chalo, I will ratify. Means I will pardon. I will accept it now. Post factum acceptance. After the event, when I accept what has been done, even though it is irregular, it is called ratification. Okay? Anna, Hitechenji, if you have understood, just put a line there saying, I have understood, sir, like that. Or, I have understood also. Then I'll be very happy. This is what ratification means. It's a very important legal term. You will come across its ugly face in agency, agent pay ratification, like that you will come regularly, you will come across this word. It's a legal term. It is important for you to know what it means. Okay. Now, Sri Ranjini Sinha gives a nice thought. Let's look at that. Constructive notice, just like we click the agree button to terms and conditions even without reading it, when we want to have access to some apps or sites, it is presumed that we have already read it. Wonderful, Sri Ranjini ji. Exactly. You put that click there now, then it is you are deemed. It's doctrine of constructive notice. Tomorrow you cannot tell the credit card company or the seller or whoever it is. Somewhere in the terms and conditions they might have put a clause, no return of goods. Like that. Sorry, you are bound by it. Okay? Cannot say. Chalo. Good. Now, so this is basically what is the doctrine of ultra vires. Doctrine of ultra vires says anything which the company itself cannot do, the members cannot ratify. Where something is beyond the powers of the company, even the entire unanimous resolution also cannot ratify. Now, how do I decide what is within the powers of the company, what is beyond the powers of the company? Simple. You just have to look at the memorandum. Look at the objects class of the memorandum. Look at the objects class of the memorandum. Whatever is stated there is that is what they can do. What is not stated there, they cannot do. For example, if the company has been incorporated for the purpose of building, developing, then construction company, then such a company enters into a contract for, shall we say, it can enter into a contract for buying and selling cement and all, which is necessary. What the company cannot do is set up a software consulting company, software IT technology park, because that is beyond the scope of the memorandum, which means any contract entered into which is beyond the scope of the memorandum object clause is void ab initio. This is the doctrine. A contract entered into which is beyond the scope of the objects mentioned in the memorandum of association is void ab initio. Basically, the doctrine of ultra-vires is about capacity. What the company can do, what the company cannot do. Earlier, you might have learned that miner's contract is void because he has no capacity. So even if the miner enters into a contract, the contract cannot be enforced on him because the contract is void ab initio. Ab initio, again, Latin term meaning void from the beginning. Ab initio, from the beginning. Okay. Similarly, a contract entered into by a company which is beyond the scope of the memorandum is void ab initio. This is the doctrine of ultra-vires. The purpose of the doctrine is twofold. First is, it is to protect the investors so that they may know for what purpose the money will be employed. Now, to protect the creditors so that the fund to which they must look for repayment is not dissipated in unauthorized activities. So, you are an investor. You have invested in the company based on the memorandum. You have read the memorandum and therein you find the object class. Now you find that the contract entered into with the company is within that scope. No problem. Intra-vires. You can sue. But suppose you have not seen the memorandum. That is your problem. Why? Because even if you have not seen it, doctrine of constructive notice says it is presumed that you have seen it. Okay. So I would humbly suggest Mandanjali not to think of ultra-vires and constructive notice as opposites. Constructive notice is the basic presumption. That is always there. Ultra-vires is the first doctrine. Later on we will see indoor management. That is the reversal of ultra-vires. That will protect the third party. Got it? This is meant, the doctrine of constructive notice is a basic doctrine. It says, if you are a third party and you want to deal with the company, you should read the public documents. You have not read it, then that is your problem because it is presumed that you have read it. That's all. That's about it. Don't link it with these two. That is a basic doctrine. You have to understand it. Arising from that, what we say, you are a third party, you should have read the public document. In case this object is not in the memorandum, then the contract is void ab initio. Now, although this is supposed to protect the investors and creditors, think about it. Who is the real sufferer? The third party. Why? Because the contract is void, Baba. Let us say that I have supplied goods. I cannot sue. Why? Because it is not in the memorandum, boss. Company can come and lift the head and say, I can't pay. Right? Because it's ultra-vires. Whose fault is that? Because the third party did not look at the public document. But he is presumed to have looked at it. So in a way, the doctrine of ultra-vires is actually a pain. But it is there not to protect the third party, but to protect the investor. Think about it. I have invested 1 crore in this company. For what purpose? For the purpose of constructing a hotel. Let us say hotel. Now this fellow, the owner of the directors, rascals, what they are doing, they are entering into a contract, say, for building an amusement park. Now amusement park is not there in the articles or in the memorandum, nowhere. So when I invested the company, there was no mention of amusement park, blah, blah, which means my money cannot be used for building amusement park. Similarly, the creditor who lent 5 crores, his money cannot be used. So, suppose this company enters into contracts for machinery, okay, purchase of machinery for amusement park. Those machinery fellows have supplied and they come for the money. Now, let us say in the meantime, the company goes into liquidation. For example, at that time, the liquidator can simply say, sorry, I cannot pay you guys. Why? Because your contract is void ab initio. If you have received any money against that, please return it to me. The court will enforce that. They will say, no money should have been paid to them on these cases. So give it back. Because the contract is void ab initio. Who is it protecting? It is not protecting the third party supplier. It is protecting the investor and the creditor whose money is locked there. Why did they give it? They gave it for hotel. Okay. So this is I know it sounds a little confusing, but wrap your mind around it. It's very important. Doctrine of ultra vires is not meant for protecting the third party. In a way, it's actually against the third party. You can say an unwary third party or a buddhu third party may get caught. Some company may cheat him, which is why as a member of our institute and an advisor to clients and to your corporate heads, MD and all, before you deal with a company, please ask for them, go to the website and download the memorandum or see the memorandum. Ensure that whatever dealing you are having with that company is within the memorandum. This is an important legal point that you might want to insist. In case you join a company at a higher level, please do a vendor search. Whichever vendor or whichever customer is a company, please see the memorandum and clear it as part of vendor evaluation, as part of customer review. Do it. This is an important, shall we say, corporate policy. In fact, wherever I audit, wherever I set up SOPs for my clients or standard operating procedures, automatically I put this in. Before, if it's a company, vendor registration formality includes MCA site. Okay, if necessary, you hire a company secretary to do it for you and give a report so that you know what you are letting yourself into. More so when you are supplying, be sure that the customers, it's a company, the object clause has the object for doing this. Otherwise, you might supply goods and you cannot collect. So be careful. Okay, this is the practical commercial implication of the doctrine of ultra vires. So when you are the third party, protect yourself, right? Are you able to understand it this way? Okay. So as we already said, the competency to enter into a contract is the point. See, company is an artificial person. It cannot have a body or mind. It does not have a body to be hurt, nor a soul to be damned. I'm a natural person. You are natural people. We have a body which can be hurt and hopefully a soul. I do. I'm sure I have. I don't know. Okay. A soul to be damned. So, but the company does not have one. Then how do you say company is doing that? Everything is dependent on what it says in the memorandum. So hence competency for a corporate is determined by its own charter, namely the memorandum. That too, the objects clause of the memorandum. If the company has to do something, it should be there in the objects clause of the memorandum. Which is why they say the corporate life cannot be spent for any purpose other than those specified in the memorandum. Very famous case, Ashbury Rail Carriage Company versus Riche. See, this Ashbury Rail Carriage Company got a contract for laying railway lines. They also entered into contract with this fellow Riche for some things to do with manufacturing coaches. Actual coaches, railway coaches. They were manufacturing railway coaches, but they entered into a contract for laying railway line with Riche. Now Riche filed a suit. In the meantime, the Ashbury Rail Carriage Company went into liquidation. Then the liquidator said, I cannot pay you to Riche. And Riche filed a case in the Chancery Division, which is the lower court, like in our High Court. Sort of that got, our first appellate stage, it got, the Riche lost. Then he went to the House of Lords, which is similar to our Supreme Court in England. He went to the House of Lords. And there, this particular decision, Ashbury Rail Carriage Company was Riche, was laid down by a very famous judge called Lord Macnaghten. The statement is beautiful. My guru, Professor K. S. Anantharaman, when I was learning from him, because I was a special student, he used to give me the original case law. I have read the original British judgment of Ashbury Rail Carriage. He made me read it, and we had a discussion on what is Ashbury Rail Carriage Company versus Riche. This quotation, the corporate life cannot be spent for any purpose other than those specified in the memorandum, is Macnaghten. In fact, Macnaghten goes on to say, not even all the shareholders can ratify an act which is ultra vires the memorandum. Not even all the shareholders can ratify or pardon or accept an act which is ultra vires the memorandum, which is why the memorandum is very, very important. So before you deal with the company, please ensure that you have read the memorandum and deal. If you are representing a company or a vendor or a supplier, right? Be careful. This is the practical way I will understand. Otherwise, it's all theory. Yeah? All this is in the books. Just mug up, vomit, get, qualify and go. But you and I are chartered accountants. Anything that we study, there should be an application. And according to me, this is the application of Doctrine of ultra vires. In fact, it's a very big topic. For our institute purpose, they have reduced the content. Otherwise, it's a very interesting. There are about, along with Ashbury Rail Carriage, there are 3 more cases which you have to know. But bottom line, again and again, circling this memorandum. Now, I gave one example, no? What is an example? I said, the company I invested in was supposed to set up hotels. Now they want to construct an amusement park. Can they do that? Yes, they can. Can they use my money for that purpose? Yes, they can. Provided, listen to me, provided they amend the memorandum object clause. The object clause of the memorandum should be changed. They should include an object for construction of amusement park. That has to be approved by special resolution. So they have to come to the members. Then they go to the members and convince them. Boss, we plan to build a hotel. Your money was given for that. No doubt. But now we feel that there is a better opportunity in amusement park. What do you say? Shall we build an amusement park? So if all the members present, they raise their hand, or 3 times the number of votes cast against raise their hand, then chalo, decision is taken by the company, memorandum is altered. Now you can go ahead and do it. So the procedure, if you want to do something which is not in the memorandum, first amend your memorandum. I have done this for many clients. They'll come to me and say, sir, we want to start a new business. First thing, take the memorandum. It's not there. Amend the memorandum, then start doing whatever you want. Got it? So that is the only cure. Okay. So we have already seen the doctrine of constructive notice. Now, all said and done, some of you will be feeling, hey, sir, this is all nice. You are telling something. Hello, Snehal. I am repeating 100 times. I am telling I will share on Saturday. Which part of the sentence you are not able to understand, Snehalji? I am telling I will share it now. Okay, good. I will not share it now. I will share it only after this session is over. Means this topic is over. I will share PPT for this topic. Which part of the sentence that I told now you cannot understand, you tell me. I will clarify. Okay, Snehalji, got it? This is my condition. As a guru, I am telling this is how I will operate. You are happy? Please. Okay. Don't worry. You will get it, Baba. You will get my slides. My slides are a public document now. So many students are using it for exam. They are downloading it from the site. Already, earlier batches slides are already there. See, that day what happened? I wrongly typographically put 182. Then it got corrected to 180. Like that, some corrections may happen. I want to put everything thoroughly in, and then that completed slide will come to Yunga. That's all. That is the rationale behind my decision to not to give it after. And the two, see, if I break it and give it now, the topic cannot be broken like that and given. It's a complete comprehensive topic. Let me finish it, then I'll give it to you. That's all. It's simple. Come on. Don't be so studentish mindset. No? Become a professional. I want you to all think like a chartered accountants. Mr. Bhupati, our famous past president of our institute, my guru, Mr. R. Bhupati, CA R. Bhupati used to tell us, when he taught us income tax for intermediate, he used to say, don't think like students. Think like chartered accountants. you will become a chartered accountant. If you think like college student, blah, blah, notes, then you are still a student. Notes will come, Baba, but understand the subject. Okay, that is more important. Okay, good. Now, I will agree with you totally if you say, sir, still the doctrine of ultra vires is a danger for the third party. Third party has to be very careful, absolutely. But the doctrine of indoor management, it seems to protect the third party in a way. The doctrine of ultra vires put the third party in a little bit of a danger. The doctrine of indoor management gives the third party some freedom. What does it say? We'll see that. Before that, Vikas Bansal is summarizing my point. And it says, simply means ultra vires as per memorandum can be ratified except, no, it cannot be ratified. Once it is beyond the memorandum, gone. If you want it to be valid, then you have to amend. I think I have confused you. I'm sorry. Doctrine of ultra vires, sat aaj to dekhiye na, if it is not in the memorandum, if you have entered into the contract is void. That's all. Doctrine of ultra vires is supreme. But if you want it to be valid, then before you enter into the contract, you have to amend the memorandum. That's all I said. Okay, be clear. Later on, you cannot amend the memorandum and nothing will happen. For future activities, it will work. But for the past, gone. Clear, sir? If what I have told is clear to you, Vikas Bansalji, please say, yes, I have understood. Because I don't want you to go to bed today with the feeling that suppose the contract is entered into and baad you amend the article memorandum, it will be okay. No. Only for future transactions, it will be okay. For past transaction, void. Sir, clear, sir? I hope I have communicated. Please just confirm it, because I don't want you to go to bed today with this wrong idea after attending my class. Okay. Chalo. Now, yes, definitely third party, it is a little bit of a problem. What do I do? So the law says, look here, the third party is supposed to have read the memorandum articles, public documents, and understood it. But he cannot find out whether that was actually done or not. That is, if the company says it is done, it is done. That is the doctrine of indoor management. See, a transaction. Okay, I just ate few words. I don't know what he means by that. Anyway, we shall presume that Vikas Bansal has understood. So it's a doctrine of ultra vires operating for Vikas Bansalji. Because he heard what I said, it is presumed that he has understood what I said. Okay. Doctrine of ultra vires. Straight away. Now, doctrine of indoor management. Sir, I am a third party, sir. I read the memorandum, sir. I read the articles, sir. Articles very clearly says, directors, if they want to borrow money beyond 2 crores, they have to get a resolution passed by the members. Directors can borrow only up to 2 crores. Beyond 2 crores, they have to get a resolution passed by the members. I have verified, sir, articles. Then I called you up. You are the company secretary. I asked you, Baba, have you passed the resolution? You said, Ji, passed. Then what you did, you also gave me a piece of paper saying resolution copy like that. I took it, put it in my file. Then I lent the money to you, 3 crores. Can I sue you? Yes, I can. Is the contract valid? Yes, it is. Why? Because I know that there is a 2 crore limit on directors. I'm aware. So, doctrine of ultra vires, I'm aware. I asked you. You said you have passed. More than that, I asked you for the proof. You gave me a proof purporting to be a resolution. I don't have to go beyond that. If I go, it will go indoor. I will enter inside the boardroom. I cannot do that. Which is why they say, yes, a transaction may have 2 aspects. Substantive, what has to be done, and procedural, how it is to be done. An outsider may be presumed to have knowledge of both the substantive and procedural aspects. What is to be done and how it is to be done, I can find out from the memorandum and articles. But how can he find out whether the procedure has been actually complied with? I can't do that here. Therefore, he can presume in his favor that things which ought to have been done regularly have been done regularly. This is known as the doctrine of indoor management. Okay. So this is now operating in favor of the third party. So if Mantanjali wants to have an opposite relationship, then I would say the doctrine of indoor management is the opposite of doctrine of ultra vires. Ultra vires, presumption in favor of the company. Third party has read it, so contract is void. Indoor management, presumption in favor of the third party. What does it say? Third party can presume that what has to be done has been done correctly. Tomorrow the company cannot come and say, you know what, that resolution was never passed, a meeting was never held, blah, blah. Hello, brother, that is not my problem. I asked if you passed, you showed me proof. That's all. Whether that resolution was passed to find out what I should do, I have to come inside your door house. I can't do that. I need not do that. That is why this doctrine is called Doctrine of Indoor Management. This doctrine was first laid down in the case called Royal British Bank versus Turquand. Okay, that's why sometimes it's also known as Turquand's rule. Sometimes, they'll call it by the name of the case law. So here they use the word Turquand's rule. The doctrine of indoor management is also known as Turquand's rule. In this case, a company had powers to borrow money provided a proper resolution was passed. The company borrowed money and issued bonds. The resolution was not in fact passed. See, the creditor who lent money, what he would have done? He would have read the articles, resolution, show me, reco, seen, copy is given, file, money lent. That's all. If the resolution was not actually passed, only paper was given to me, that is not my problem. It was held that the company was bound. The fact that resolution was not passed did not affect the bank. See, the Royal British Bank has lent. So they are not bothered. Okay. So the bank was bound to inspect the articles, which it did. They asked if you have passed the resolution. Fellows gave some paper. I put it in my. Beyond that, they were neither bound nor entitled to look. Otherwise, it would take them indoor. That is behind the closed doors of the company's boardroom. I cannot go there. That's why it's called Royal British Bank versus Turquand. There is another case law also, Howard versus Patent Ivory Company. Similar, where the word actually indoor was used in that case law. Howard versus Patent Ivory Company, where the word indoor, otherwise it would take them indoor, was used in that case law. Okay, but see, fundamental question that some of you may be boiling in your head is, should I remember all these case law, blah, blah, sir? Yeah, try to remember some of these well-known case laws. Okay, if you find it in the institute's material, please remember it. Don't go beyond that and try to mug up case laws and all. But see, Ashbury Rail Carriage, Eley, Turquand, these are all famous case laws. It's good to know them. Okay. So, yes, there is a case law of Turquand Bank. That's what I'm showing you now, madam. This is the case law. You may remember that if you want. Wonderful. So, doctrine of ultra vires is the opposite of indoor management. Doctrine of ultra vires is in favor of the company. Doctrine of indoor management is in favor of the outsiders. Beautiful. Now you have understood. Excellent. Okay, fantastic. Now, there are a few exceptions to the doctrine of indoor management. See, the doctrine of indoor management is an exception to the doctrine of ultra vires, where the procedure is known to the third party, but he need not find out whether actually. To that exception, there are 4 exceptions. First exception, persons having actual knowledge of the irregularity. I will explain in a simple way. See, in the articles, there is a provision which says, up to 2 crores directors can borrow. Beyond 2 crores, they have to go to the shareholders. Now, one of the directors is lending 3 crores. He knows that the resolution has not been passed and he is lending money. He cannot plead a doctrine of indoor management and say, hey, I read the articles, blah, because you are a person who had actual knowledge, Baba. You are a director. You are very much indoor. You are indoor. Such a man cannot say, I'm not aware. Only total third party who is outside, can claim the indoor management. A director who is having actual knowledge of the irregularity cannot claim. Logic now. Similarly, suppose the person is purporting to act as director. Slight difference. This person is not a director, but he is purporting to act as a director. In another case law, what happened? Two people, one who was resigned and other who was not a director at all, They appointed one M as a director. Morgan versus Canson. Okay, is a case law where they appointed M as a director. Now, one fellow already left, not a director anymore. Second fellow was not a director at all. These two donkeys together are appointing M. Now, M is here truly a third party who can claim doctrine of indoor management? No, because you have purported to act as a director. Baba, you say, I am also a director, like that you're telling. So, Morgan, that M cannot sue. He cannot claim doctrine of indoor management, they said. Okay. Now, forgery. See, a forgery is a nullity in law. At every stage of forgery. See, for example, suppose the bank, suppose checks are sent to the bank. Clearly stating, see, the company's checks should be signed by the MD, right? The MD signature should be there with the bank, right? Instead, if the company secretary forges the MD signature and the bank clears the check, see, the company secretary forges the MD signature and presents the check. Possibly in his own name or some benami name. That check is cleared by the bank. Now the company is suing the bank for the recovery. The liquidator is suing the bank for the recovery. Bank says, no, indoor management, I'm a third party, how can I know? Sorry, this is not about procedure, this is about forgery. You are supposed to be sure that you don't pass a forged check. Where the signature is not tallying, that is not indoor management. That is forgery. As a bank, you are supposed to protect the customer. You have not done it. You have to pay to the person. Forgery is a nullity in law. There you cannot claim doctrine of indoor management. Lastly, persons put on inquiry. See, again a banker. The MD is depositing checks which are payable to the company. The MD is, every check comes, it is payable to the company. It is being, later on in negotiation bill instrument act, you will understand. It is being endorsed. It is being transferred to the individual, that MD's name, and he is deposited in his personal account. And it is cleared by the bank. Sorry, one check, two check, okay. When 6 checks the man is coming, all are in the name of the company, but he is endorsing it as MD of the company for and behalf of the company. He is endorsing it and putting it in his personal account. You are put on inquiry. As a banker, you should ask him, hey, what's happening here? Having failed to ask or make the inquiry, they cannot claim doctrine of indoor management. Right? These are all famous case laws. For each one of these, there is a case law. Like persons having actual knowledge of irregularity, Morgan versus Canson, Rubin versus Great Fingal, some company, Great Fingal company, something. Famous cases are there. They are all very famous cases. Okay, Bank of Liverpool versus A.L. Underwood. That is persons put on inquiry, all that. Okay, so if you cannot remember the case laws, no problem. Okay, just wanted to tell you. Wonderful. I know some of you might find the doctrines a little heavy because they are basically theory, but they are the underlying conceptual foundation of company law. If you are thorough with these conceptual foundation, future as a senior chartered accountant when you are 35, 40, the level of command over your profession will be different. People who are simply mugging up and vomiting and so-called updation on the peripheral level, yeah, they are at one level. But people who have core principle conceptual knowledge, even when the law is changing, the principles will not change. People who are strong in principle, changing law, they can easily adapt and come. But people who are not strong in principle, simply mugging up the current amendments and all and being up to date, that's not really, so they will not know why this is happening, but they'll mug up and say it's happening like that. Whereas we will give solution which is based on principle to the client. Say, boss, this is what it is. You do like this. We can even advise the government and say, look here, this is the purpose. Don't do like this, do like that. For that, you need conceptual knowledge. Okay. Not only in company law, in every subject, in income tax, indirect tax. So, whichever subject you say you want to become an expert in, conceptual knowledge. Right. Chalo, sir. Wonderful. We have come to a nice level of knowledge of incorporation, etc. Because this going back and teaching going to be very difficult. I may not be able to do that. If you have a specific doubt on 2 and 4, please raise it. I will answer. Okay. If you have a specific doubt, I cannot go back and explain. Time is not there. Okay. Very difficult to explain. Also, according to me, not very important. If you have, see, forgery is the nullity in law. 2 and 4 is it? See, the guy is a director, see, 2 people who are not directors are appointing a third party as a director. This act itself is stupid, wrong. Now that the guy who was appointed as a director wants to sue the company, but then how can he? Because he claims doctrine of indoor management. He says, what happened inside is not my problem. But he can't say that because he himself is purporting to act as a director. How can he claim the doctrine of indoor management? The distance is not there. In fact, the difference between 1 and 2 is that in 1, the person having actual knowledge of irregularity is actually a director. Here, he is purporting to act as a director. Persons put on inquiry is a very, very legal thing, See, bank has to be very careful. So when the MD of a company deposits checks which are meant in the name of the company, he transfers it to his own name and deposits in his name. That is called endorsement. On the reverse side, see, the problem is your knowledge of negotiable instruments is not there. Once you understand endorsement, you will understand this. So he simply reverses the checks for and on behalf of the company. He endorses it and says deposits in his account. When he does that, right, nothing wrong. But then the bank is put on inquiry. Continuously when checks are being deposited in the personal account of the MD, which are meant for the company, bank has to make an inquiry and ask, why are you doing it? What is happening here? They should have done it. Not having done it, if they have cleared the check, the company is entitled to collect the amount. Okay. Good. But in future, students, you should try to avoid asking me to repeat topics. Kindly do not make a request. In one line, you can ask, for me, it is 10 minutes to repeat it. So one way is to concentrate on what I'm saying. I know I'm speaking in English. I know some of you may find it difficult to understand. Concentrate on, I'm going slow, I'm using simple language. Listen to me. If you still don't understand, ask a specific doubt. Don't ask, sir, repeat slide number 25 to 34. Hey, baba, not possible. Okay, don't do that. Ma, it's not possible to explain again, ma. Yeah, Prabhas Jain is giving Reuben versus Great Fingal Consolidated Limited. Beautiful. Go and refer to that case law. Reuben versus Great Fingal Consolidated Limited. Okay. See, just now I mentioned Mantanjali ji, don't ask me to repeat again and again. You are asking me to repeat. This is the third time I'll be repeating forgery now. Forgery is a nullity in law. Suppose a bank is clearing a check with a forged signature, they cannot claim doctrine of indoor management. They are supposed to ensure that forged checks are not passed by them. Okay. So where the signatures are not tallying, third party cannot claim doctrine of indoor management. I've explained. Sorry, sometimes I sound a little rough, but what to do? This is not university class, BCom, MCom. This is CA. Okay, you should also concentrate on what I'm saying. Ask a specific doubt. I'll be more than happy to answer. But do not ask me to repeat. How many times? Hey, I also have a throat now. I'm also a human being now. Okay, here Vikas Bansal picks a big essay. Let us see what it is. Doctrine of constructive notice is assumed that person dealing with the company must have gone through MOA. Indoor management is assumed person dealing with the company must have gone through it, but you don't know if the procedure mentioned are actually followed. Exactly. Correct. Now, if you understood the doctrine of indoor management, just to reverse it, you will understand the exceptions. Only a person who does not have actual knowledge can say, I didn't know. Person who is actually involved cannot say that, is the point. Wonderful, Mantanjali. Thank you. Now we move on to another interesting and important area called alteration of memorandum articles. As I already mentioned to you, we will not be having a break today. Rather, we will go until 8:15 or 8:20 and I will close. So if that is okay for you, if it is okay, you just put a note there and I will know that it's okay for you. I'm not going to have a break. Because 2.5 hours is okay for me. It's only when the 3-hour sessions, we need a break for everybody. 2.5 is okay. We can manage it. Now, friends, just give me 1 minute to do something which I wanted to show you. But to do that, I need to stop sharing and I need to do something else. Just give me 1 minute to do that. Then I can show you something very interesting. I can show you something which is very interesting. And okay. In fact, I already promised that I will do that. I said I will show you the documents for incorporation, right? I'm going to do that now. I'm going to again share the screen. When I share the screen, I will share with you the documents for incorporation, right? So here we go. I'm sharing my screen again. Right. Now I'm going to show you the documents. See, this is a company. Consciously, I have, concealed the name of the company, right? What I'm now showing to you on the screen is a certificate of incorporation. This is the e-certificate of incorporation. What you're now seeing on the screen, it's called the certificate of incorporation. Pursuant to subsection 2 of section 7, subsection 1 of section 8, this is the, I hereby certify that so-and-so private limited. You can say Practice Company Private Limited is incorporated on this 13th day of May. This was a company that I recently incorporated for a client. So that date is 13th. So the 13th day of May is the birthday of this company. 13th day of May 2022. This is the real certificate of incorporation of a company which was incorporated on 13th of May. For the sake of privacy, I am removing the name of the company. Though this document is a public document. Anybody can go and see it. But still, for the sake of, because I'm a chartered accountant and I'm not supposed to reveal my client's data, I'm hiding the name of the company. Do you see this? This is called corporate identity number. Corporate identity number. Okay. Corporate identity number. CIN. C-I-N. Corporate identity number. This is a unique number which is given only for company. Even here, my office has hidden the alphanumeric string here, alpha string here, which would give an indication of the name of the company. So, but this is the CIN. Along with the CIN, the PAN is also issued. As you can see, they have hidden the PAN also and the TAN for safety purposes. Afreen Khan has seen the COI and all, but other people might not have seen, no? For their sake, shall we show, Afreen? What do you say, Afreen ji? For their sake, shall I show, or no, sir? Don't show all these things. Then you tell me, I will stop showing. Otherwise, I will show. Because I thought it will be interesting for some people to see it. So just give me a heads up to continue. Shall I show it? Yeah. Now, please note one important point here at the bottom, the seal, of course. More importantly, mailing address as per record available in the Registrar of Companies office. This is only the mailing address. This is not the office, registered office address. They are simply confirming the mailing address. This company has its office in a place called Tirunelveli in Tamil Nadu. In fact, I was there yesterday, not to meet this client, but for another meeting. I was in Tirunelveli in south, in remote south of Tamil Nadu. There is a town called Tirunelveli where I was there yesterday. I came today morning and I'm now in another place called Pondicherry, okay, where I'm sitting here now. So I have become a person like, I have become a Banjara. I have become an Adodi, Banjara. I keep traveling all over the place. I don't know where I will sleep in the night, in which city, which place I will sleep. I don't know. I keep on traveling. Occasionally, I come to Chennai where I live and I stay there. Sometimes I go to Coimbatore where I live and I stay there. Seriously, I don't know where I live, what I do. Matascha Parvati Devi, Pita Devo Maheshwaraha, Bandhava Siva Bhaktascha, Swadesho Bhuvanatrayam. It's a very famous verse. Okay, Bandhava Siva Bhaktascha, Swadesho Bhuvanatrayam. The whole world, the three worlds. You can go. There's no need for you to have, this is my place, your place, like that. Every place is our place. Okay, chalo. This is the so-called Spice Plus form. which you fill to incorporate the company, where you have to give a description of the main division. What is it? I told you, it's a construction company, whether it's a company limited by shares. Here, each one would be a drop-down option, I should say, in the software. When you go online to the site, each one would be a drop-down. Once you fill the drop-down, they'll get frozen. So you can choose if it's a new company, what type of company. Sometimes you might want to change the name and all, then existing company. Then if it is an LLP, or if it's whether it's a private company or a public company, whether it's a company limited by shares, guarantee, unlimited, blah, whether it's a non-government company in case, or is it a government company, all that. So objects, here what we have done, we have put the objects in a separate attachment. I will show you when I show you the memorandum. And particulars of the name, proposed name. So we have given that name. Obviously, it's hidden here. We have given the name. Similarly, whether the articles of association is entrenched. Do you remember entrenchment? Here we are saying no. Suppose we say yes, then we have to give which articles are entrenched and what is the nature of the entrenchment. So we might say serial number 1, article number 12. This article pertains to admission of members. This can be done only with the approval of all the shareholders. Entrenched. Like that. Then capital. So we are giving the capital structure. This is the form. This is not the memorandum. This is the form where we are giving clearly what the shares, how many shares, etc., etc., etc. Address of the company. This is only the postal address. I'm quickly rushing over it. And form is filled up, then signed. And once the digital signature certificate signs are affixed for every director or signatory, then the form is filled, and it's a long form. I'm just skipping through it. Most of it is repetitive. Then everything is attached. Then there is this declaration. This declaration is there. Then the signatory, the director signs it, and then company secretary signs it, certifies it, and then this can also be certified by chartered accountant. This part, even a chartered accountant can certify it. And then this can be done by a chartered accountant also. As you can see, CA can also do this, company secretary can do it, cost accountant can do it, advocate can do it. Then it will be done. And then digital signature of the authorizing officer will be fixed. Then the signatories also will affix. Everything will be done. Then the spice will go. This is the Memorandum of Association. Memorandum of Association. In addition to that, we'll also have a printed memorandum for giving physical copy. This is straight away can be downloaded from the website. So here you will find this is the main object. The objects to be pursued by the company on its incorporation are, you can have maximum 3. We are given only 1. Do you see how elaborate I have put it? To carry on business as builders, property developers, engineering contractors, civil merchants. In fact, he wanted realtors also. We put realtors. Everything we put. Real estate brokers, realtors and agents. Everything we put. Anything to do with real estate and building construction and promotion, we put it here. Then these are incidental or ancillary matters which are necessary for furtherance of the objects. As I told you, ancillary objects. Then this is memorandum. Then this is the object clause of the memorandum. Ancillary objects, quite a long, you can put a lot. Then once that is over, liability. This is the liability clause. The liability of the members is limited. And this liability is limited to the amount unpaid, if any, on the shares. Share capital. This is the authorized capital. This is the authorized capital, 1,500,000 shares. Now, this is the subscription clause, clause 6. Do you see that? Clause 6. Please read the words. We, the several persons whose names and addresses are subscribed, are desirous of being formed into a company and in pursuance of this memorandum of association, and we respectively agree to take the number of shares against our respective names. Okay. The second one is for a OPC. Then 7th clause will be there giving the single member's name. 8th clause will be there for OPC giving the nominee's name. For a normal private company, no such thing. Then these are the subscriber details. So each subscriber agrees to take some number of shares, right? So on and so forth. Since most of you would have seen AOA and all, I'm not going to waste your time on this. What I wanted you to see was the memorandum, right? The memorandum of association. I wanted you to see it. This is the actual memorandum content, right? So this document is a public document, and it has to be, you know, sort of, you can always download it, see it before you enter into a contract with the company. Every third party can do it. So up to now, what we have done is we have discussed the topic relating to we have incorporation of a company, procedure for incorporation. Also, we have seen what is the memorandum, what is the articles. We have also seen how the memorandum and articles are to be, what is the content of the memorandum and articles, how we will. No, sir, we are going to go on without a break till 8:20 or 8:15 or 8:20. That students also want that. Is that okay? Please, sir. I will go on without a break till 8:15 and I will stop. If I need, I will go till 8:20. Otherwise, I will stop. Okay? So, up to now, we have seen what is the memorandum, content, etc., doctrines and all. Now, we are going to start talking about alteration. Means how to change the content of the memorandum. How to change the, shall we say, clauses. Various clauses of the memorandum of association. How to change that. Okay. So, alter has been defined in the definition clause. I don't know if I'm sure you would have studied it in definitions. The word alter or alteration includes the making of additions, omissions, and substitutions. A clause can be, you can add something to that clause, you can take something out of that clause by omitting, or you can take out an entire clause and substitute with a new clause. Suppose that company which I showed you wanted to have a new object, change the object, entirely different. Then what they will do, they will substitute the existing object class main with a new. That's how they will pass a resolution. Resolve that the current existing object, existing clause 3, name, domicile, third is object. Existing object clause 3(1) of the company be and is hereby substituted by the following, and then they will give the new one. So that once the alteration is approved, the memorandum will be changed. The old provision will be taken out and the new one will be put. So basically section 13 deals with alteration of memorandum. And what does it say? It says the memorandum may be altered. The company may alter the provisions of its memorandum with the approval of members by a special resolution. By a special resolution, right? Now, later on, we will discuss about what is a special resolution, right? Later on, we will discuss what is a special resolution. Just for your information, ordinary resolution means simple majority. Means number of votes cast in favor should be more than the number of votes cast against. If 2 people vote, suppose 3 members are attending, This is a very, very complicated topic. Don't go there. Don't ask me a question on this topic. This topic will be covered later. Only for immediate understanding, simple terms I'm telling. This can be complicated. I can complicate it. But right now, what I want you to understand is, suppose 3 people are attending in person. 3 members are attending in person. A resolution is put to vote. 2 are for. 2 are for. 1 is against. 2 are for. 1 is against. Resolution is passed as an ordinary resolution. No problem. But special resolution, you know what they say? The number of votes cast in favor should be 3 times the number of votes cast against, if any. In our example, what happened? 3 people attended. 1 against. That means what? Minimum 3 should be for. The number of votes cast in favor should be 3 times the number of votes cast against, if any. So, not passed. Suppose 5 people are attending. 5 people are attending. 1 is against. 1 is against. 1 is neutral. He says neither for nor against. Sorry, not voting. Pass. 3 are for. 5 people are attending in person. Resolution is put to vote. 1 is against. 1 is neutral. 3 are for. Have I passed a special resolution? Yes, I have. How? How many votes are cast against? 1. Neutral is not against. Neutral is neither for nor against. Excluding. So, which means only 1 vote is cast against. Neutral is not against. Neutral is not for. He won't be counted. So, only 1 vote against, multiply by 3. 1 into 3, 3. So, the number of votes cast in favor by members present and voting should be 3 times the number of votes cast against, if any. Here, 1 vote against. So, 3 votes for. Special resolution passed. That is all. Later on, I will come to that section and I will teach in depth. Don't worry. But essentially, it's as simple as this. So, don't confuse yourself with 2/3 majority, 3/4. Nothing. 3/4, 2/3. What is that? 3/4 majority, 75%. Nothing. Okay. So, the number of votes cast in favor shall be the number of votes cast in favor by members present and voting. So, not only should he be present, he should also be voting, which is why neutral is not counted. He is not voting. Okay. Present and voting shall be 3 times the number of votes cast against, if any. If you have understood this, special resolution over. In fact, when I come there, I don't have to waste too much of my time teaching you. Why I am doing it now, you might ask me. Why are you now? Because this word special resolution will be coming again and again in our lectures. So every time, I don't want you to have a doubt what it is. So this is the thing. Okay. So, yeah. Special resolution. So for altering the memorandum, there is a special resolution. For altering the articles, you have to pass a special resolution. The conditions contained in the memorandum, subject to the provisions of the Act and the conditions contained in its memorandum, a company may, by a special resolution, alter its articles. So please note one thing. For altering memorandum, only I have to see the Act. Memorandum it should not be contradictory to the Act. Any amendment to the memorandum should not contradict the Act. But if I want to amend the articles, I should also comply with the Act and I should also comply with any condition. If any condition is there in the memorandum, that will also apply. Which means the hierarchy is like this. Articles is subservient to memorandum. Memorandum is below Act. So both memorandum and articles are below Act. Articles is below both memorandum and Act. Okay. So articles have to comply with Act and also memorandum. So this is alteration. What Please tell about attachments required for Spice Plus. The same attachments which are there in the slide. What is that? See, actually, there are very many attachments and all. That is a pure procedure. Our institute exam very clearly does not have procedural knowledge. You might ask me, why did you then show this to us? Only to give you some practical flavor. Only to show. Otherwise, it will be an animal that you have never seen. Unless, except for my dear friend Afrin Khan, nobody else would have possibly not seen it also. So for that dosham to be removed, I showed you. That's all. That is, don't worry. Are you going to become company secretary? You're going to become chartered accountant. Nah. For you, it's enough if you know this much. I keep on telling you. This is not your, let the company secretaries learn all this donkey stuff, yeah. What is to be attached, what this document, that document, filling, filing, forgetting. Let them do all that, yeah. You and I are going to become chartered accountants. Why I am showing, just to have a look, so that, this is what it is. That's all. You don't go into this kuppa, don't go into this, the waste, what is attachment, blah, blah. Maximum, if you want to learn it, you do your articles now. At that time, don't worry, they will teach you. Your senior will teach you. It will be your job. Your boss will say, go and file it. Then you will go online and everything you will do. Don't worry about it. That is why I'm saying, in classroom, I'm only showing it to help you have a flavor. That's all. Just like, in a zoology class, we are showing the skeleton. Okay. Then only in anatomy class, we will take it apart. That is for company secretary. Don't worry. That is a different topic altogether. Earlier, our institute had secretarial practice. Now they have said no need. For a chartered accountant, there is no need to be in-depth knowledge of filing, gailing, etc., etc. It's enough if you know the form number. I wanted to show you the memorandum ka clauses. I wanted you to see the memorandum ka clauses. That is why I showed this thing. Attachments and all, don't worry. Unless you want to become a company secretary, Aishiji, in which case, don't worry. There you will learn everything. Form, this, that, blah, 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 all that you will learn. If you have interest in that sort of thing, definitely you should become a company secretary. But you and I are going to become chartered accountants. Overall knowledge, helicopter knowledge is enough. Okay, but form numbers are important. Wherever I have given a form number, please remember that. Wonderful. So, again, this OKK abbreviation, I am unable to understand. Maybe because I'm a Gen Y, Gen X actually, not even Gen Y. I'm a Gen X. Buddha, I'm now 56 years old. So, Gen X. You people are, many of you are Gen Y. Some of you are Gen Y. Many of you might be Gen Z also. Not Gen Z. Yeah. So very young. If you're 17, 18, you are all Gen Z. Gen Z people. So, this OKK, I don't know what it actually means. OKK means okay. So, sometimes, I read it as, see the tonal way I get it is, okay, clear, sir. I mean, chalo, like that. I mean, I get that impression sometimes, the tonal variety in that okay. But anyway, it's okay. All correct, sir. Thank you, sir. Okay. Whatever it means. Thanks you for telling I am all correct. Okay, good. Maybe, see, this is the Gen Y problem. Though we trying to keep pace with your technology, your language, everything, blah, blah, still, we are not able to get along with that informality of the SMS language. Okay. Anyway, try to pick up long English also. What do you say? English is a beautiful language. Try to pick up long form English also. It's a grammatically correct English. When you're able to speak grammatically correct, full sentences in English, definitely you will be treated as an erudite person. A pure chartered accountant and a professional should definitely be fluent in English. Okay, within limits. Somewhere you have to be more fluent than valuable. Fluency in English is definitely a great asset for a chartered accountant. Not compulsory, but it is. If you have that fluency in English and knowledge of the subject, imagine what you can do with your life. Think about it. And if you're still young, 20, 21, it's not too late. Okay, you can improve your English. Think about it. See, Ayushi, that is not my job. Your boss has to teach you. Your 3 years is done. Your senior in your office will teach you. Don't worry about all that. Okay, don't worry about all that. Even if you don't know, it is okay. See, in articleship, it's okay. But what I want you to understand is the clauses of the memorandum. Object clause. I want you to see an object clause. If you want, I will show again also. Once more, I will show. No problem. Because somebody wanted it to be, zoomed. I will zoom it also if I can. I didn't know how to zoom it. Let me see if I can. Yes. I have zoomed it. Now I will show you the object clause of the memorandum. That is very important. I want you to see it because I'm going to talk about alterations. This is the subscription clause. Let us see. Okay, so these are all important clauses, and see, these documents are all there. Yeah, all nonsense documents. They will ask the memorandum of association, which you have already done, which we have done in e-format, declaration of by first subscribers, proof of office address. One lease deed will have to be scanned and given. In case lease deed is not there, then they want copy of EB. It's all nonsense they will ask. Stupid things and all they will ask. You have to do all that nonsense. Donkey's job. All that you have to do. That's not your... As an article clerk, yes. But as a member, why are you bothering about all these things? Okay. Proof of identity, all that KYC blah. Okay. They will ask all sorts of KYC from people like you and me who are innocent here. But the real terrorist, when he wants things, they'll give immediately. Whatever he wants. They want to. This is the memorandum, the object clause. Just wanted you to see this. So if you want, suppose you want to remove this and you want to put something else, then substitute this. Suppose you want to add one word here, then in clause 3A of the memorandum, after the words metalware, the words glassware will be added. Like that, you have to amend the object clause. So this is what it is all about. Fantastic. Now, coming back to our alteration, we will go in depth. First is procedure for alteration of I cannot see what it is. Name clause. Okay. Procedure for alteration of name clause. Name. Any alteration of memorandum requires a special resolution. Got it? But change of name, in addition to passing a special resolution, you should also obtain the approval of the central government in writing. Right? Because changing name, sometimes companies will change the name in order to escape the liability from the creditors. Change the name and run away, or change the name. So before you change the name, the central government will want to know whether you are correctly doing things, whether you have filed your annual return, financial statement, are you a good company? Only then you can change the name. So merely passing a special resolution is not enough. So first step, you call a meeting and pass the special resolution for alteration of the memorandum. Second step, obtain approval of the central government. Now, whenever you see the word central government, you have to be very, very careful. Central government is a wide term. There are so many categories. The registrar of companies is one aspect of central government. The regional directors who are there for each region, the RDs, they are central government. Delhi, there are people there now, the deputy directors, assistant directors, directors, they are also central government. Okay, but by and large, most of the sections of the Companies Act, the power of this Ministry of Corporate Affairs has been delegated to the regional director. So, wherever the word central government is used, it will be regional director, the RD will be having the power. So you have to make an application through the MCA portal in that form INC 24. INC 24, which is based on Rule 29 of the Companies Incorporation Rule. That Rule 29 only now we are seeing here. That Rule 29 only I am now explaining to you. So first you have to pass a special resolution for alteration. Means what? Resolve that the subject to the provisions of Section 13 and other applicable provisions of the Companies Act 2013, the Memorandum of Association of the company be altered by substituting clause 1 with the following clause. Then what we'll do? The new clause 1 will be there. The name, maybe the earlier name of the company was Dubakor Limited. Now you will change the name to Fraud Limited. The name of the company, or you can say the new class. So the name of the company is Fraud Limited. New name is being adopted. I'll be showing you that also for that. I'll show you one alteration of name documents also if you want. Okay. So you have to obtain the approval of the central government in writing, and then the registrar, what he will do, before approving it, the regional director will say, what have you done? What are you doing? See, the change of name shall not be allowed to a company which has not filed annual returns or financial statements due for filing with the registrar, or which has failed to pay or repay matured deposits or debentures or interest. Suppose you have deposit holders or debenture holders, the regional director will tell, please get NOC from them. Only they say we have no objection, everything is correctly paid to us. Only then the name change will be allowed. The change of name, of course, if you have not filed all this and all, then you can change, you can file the necessary documents, repay the mature deposits, interest, etc., get an NOC from them, and then you can go ahead with the change of name. Now, do you remember the two pillars of company law? Which pillar is being supported here? The creditors are being protected here. Before name change, the creditors have to give their NOC. So you can't simply change the name. First you have to satisfy them. Okay, is the point. Now, once the name is changed, on any change in the name of a company, the registrar shall enter the new name in the register of companies in the place of the old name and issue a fresh certificate of incorporation with the new name. And the change in name shall be complete and effective only on the issue of such a certificate. Okay, so you have to obtain that fresh certificate of incorporation. Right. So special resolution is needed for alteration of name because it's a clause in the memorandum. Also, you have to obtain the approval of central government. Then only entry will be made, etc. But in one case, in one situation, there is no need for you to get the approval of the central government. What is that? No such approval shall be necessary where the only change in the name of the company is the deletion therefrom or addition thereto of the word private on account of conversion from one class to another under this act. So, when you are converting private to public or public to private, what you will do? Do fraud limited. Now you will add fraud private limited. Addition of the word private. Fraud private limited. Then you will make it a public limited. You will remove the word private. So only the change in the name is only the deletion or removal or addition of the word private. Then such a change does not require approval of central government. Application in INC 24. Because there is another procedure for change. That procedure you have to complete. For change in the from private to public, public to private. Right? That is what. Clear? So this is procedure for change in the name clause. Right? Fantastic. Now, friends, let me show you again one document of change in the name document. This is my own company, so I can show you freely without any problem. I don't have to hide the name. This is a consulting company that I have. It was called Blue Dot Consulting. I'm making it as big as possible. Still, if you cannot see, then my suggestion, come near the screen and see. Okay, that will be easier. Now, so Blue Dot Consulting Solutions Private Limited was the company that I had earlier. I wanted to change the name of this company to Prometheus Consulting. I just wanted to change the name. So we have gone for the application in INC 24. And so what I've said, now the certificate of incorporation has been issued. Certificate of incorporation pursuant to change of name, pursuant to Rule 29 of the company's incorporation rules. See, I'm just trying to give a practical flavor to this topic here. So don't keep on saying, show this, show that, show this. I'm only showing what I think is relevant. See, I'm taking you through the zoo. I'm showing you zebra, giraffe. Show me all the animals. We don't have time. What I think is important, I'm showing you. Okay? What is important for you is to see the words. I hereby certify that the name of the company has been changed from blah to blah with effect from the date of this certificate, and that the company is limited by shares. So the date of the certificate becomes very, very important, right? And given under my hand means my seal at Chennai, 6th day of April. This again is recent, 2022. The gentleman K.G. Joseph Jackson, Registrar of Companies, Chennai. Yes. Okay. Again, mailing address is given. This is my address. So the address of this company. This is the form INC 24. Visana form INC 24. Right? This is that form INC 24. Friends, I may not be able to show all forms. Something that I had in my files, I'm showing you. Okay, Blue Dot Consulting is the name of the company, address, blah, blah. Now, proposed name of the company, the change name is new. Now he is asking, what is the reason for changing the name? See, the board of directors have approved it by their resolution so and so. And I think because we want to, that's all. Okay, because the board of directors has changed the name, we want to change the name. That's all. Why should I tell him why I am changing it? See, the idea is, if any other case is there, they can give the reasoning. That's the point. Sometimes, on amalgamation, they will change the name. Once the company is amalgamated with another company, they will change the name. So the new company's name, they will change like that. Joint venture, they change. Suppose one company has entered into joint venture with another, then the new company, this company would now have a joint venture partner. So that name also will be added like that. So, name of the company at the name of incorporation, etc. Shareholding details, everything is given. And a declaration for shorter notice, because notice has to be given for 21 days. We have given a shorter notice. That also they have given a letter and filed it. When I come to meetings, I'll explain this in more detail to you. What is the shorter notice and all that? Okay. And see, there's a declaration here, right? To the best of my knowledge and belief, the information given in this application and its attachment is correct, blah, blah, blah. Okay. Who has signed it? Kala Shrikant. Who is she? My wife, director of this company, right? So she has signed it, and this is, I'm showing you a very, very personal document. Nothing wrong, nothing, no secrets here. Now, this MGT 14 is an interesting form. You will come across its ugly face again and again, but you will read it only when you come to management and administration. Why? Because MGT 14 is to be filed within 30 days of passing of special resolution and other types of resolutions. When I come to that topic, I'll again show this form. Form number MGT 14 will be filed only when you pass certain types of special resolutions. Here we are filing it because we have passed a special resolution. So shareholders have passed a special resolution. Therefore, I'm filing MGT thing. So like that. Now, I just show you the resolution also, and then we can say goodbye to this. See, this is the resolution. This is the when we come to meetings, I'll again show this to you. Resolve that pursuant to section 13 and other applicable provisions. See, this is what I told you, and subject to the approval of central government, because change in name will be final only when it is approved by the central government. So, though the members are changing it, still subject to approval of central government only they can do it. Consent of the shareholders be and is hereby given to change the name of the company from blah to blah. Okay, so this is a thing. So resolve further that the existing clause 1 of the memorandum be and is hereby substituted with the following clause. Existing clause will have blue dot. Now this new Prometheus will go. Okay. Wherever it occurs, it will become Prometheus now. Okay. All these are done in the resolution. Okay. So everything is done. After this, what you have to do? You have to not only amend this, you should also amend the letterheads, visiting card, everything has to be changed with the new name. Very So, as I was saying, you should, once you are attending, suppose you attended today's class, now for 3 sessions we have gone. You take the chapter 2 and you start revising after the class. It will be good if you do that. Then my notes will come to you. Then keep it. Once more, you just last time you go through everything. Then keep it in your mind. Keep revising. Use my notes also for revising. And then you'll start answering questions. Then like that. Have a pattern of revision. Wonderful. I downloaded the memorandum and articles of Reliance Industries. Wow. Good for you. Good for you, Madhuri. That's really great. And protection reinvestment creditors are 2 pillars. Absolutely correct. So in this case, we are protecting the creditors. A company cannot simply change its name. The creditors have to be given an opportunity, especially when there is a failure to pay deposits and debentures and interest. Okay. Basically, a consulting company where we do business consulting and we do various types of consulting, financial, MIS consulting. I also do corporate training for HR and leadership and all that. Everything is done in this Blue Dot company. Now it's called Prometheus Consulting. Wonderful. So moving on. Yeah. Sorry. Now we move on from alteration of name to rectification of name. Alteration of name to rectification of name. Alteration is voluntary. When the company wants, or rather the directors want to change the name, then voluntary is the name alteration. But sometimes what will happen now? The company will have to compulsorily change, not voluntary, compulsorily change. When? Section 16. If through inadvertence or otherwise. See, sometimes we make a mistake in that. Unknowingly. Okay, without knowing, we make an error mistake. That is called inadvertent mistake. Not intentional, unintentional. So, unintentionally, if through inadvertence means without intention or without casual, they didn't know about it, casually it happened, not intentional. Through inadvertence or otherwise, that means planned. Now we'll go to that Adidas and Adibas. I'm incorporating a company with the name Adibas Sports and Leisure Wear Limited. ADABAS. Adibas Sports and Leisure Wear Private Limited. Now what happens? I go to the ROC's website. There is no Adibas Sports and Leisure Wear. And ROC also sleeping. Sorry, MCA also sleeping. I get the company incorporated. So through inadvertence or otherwise, a company on its first registration or on its registration by a new name is registered by a name which, in the opinion of the central government, is identical with or too nearly resembles to the name by which, see, this too is there in the act, but it's not a good English. That's why I put it in brackets and all. The word too is there in the act, but the way I learned English, in this place there is no too. So it is identical with or too nearly resembles the name. Is identical with or too nearly resembles to the name by which a company in existence had been previously registered, whether under this act or any previous company law. It's a very long-winded legal way of saying this company has been incorporated with a name which is similar to another company. Either identical or too nearly resemble. Even similar is okay. Now, there is no other company in India called Adibas Sports and Leisure Wear Limited. So, A class is escaped. But still B is there. In the opinion of the central government, is identical with or too nearly resembles to what to do? An existing trademark. Trademark. Now, it's not about a company. It's about a trademark. Not only identical, too nearly resembles. Friend, suppose I write Adibas, that B, looks a lot like D. Even if I tell you Adibas, sometimes it can be coming out as Adidas. Also, if I'm using a similar logo and all and making leisure wear, track suits and t-shirts and I keep selling it, I'm infringing trademark in a way. It's called passing off. Because this name too nearly resembles an existing trademark. I'm just giving an example of Adidas and Adibas. If Adidas has no objection, no problem. Okay, who has to object? Adidas has to object. Okay, but they have to go to the central government and tell them, boss, I got Adidas, this fellow's got Adibas, please tell me. So the central government is of the opinion, yeah, this is too nearly resembling your name, existing trademark. They have to prove that their trademark is registered. Adidas would have registered their trademark in US for a global patent. So that, global trademark, global mark. If it's a globally registered mark, then any country which is signatory has to protect that mark. All the countries which democratic in the United Nations now, they have signed a treaty by which they have all said, your trademark I will protect, my trademark you will protect. And once it is registered under the international treaty, which is very costly, but if you do it, then throughout the world your trademark is protected. So Adidas is protected throughout the world. Even though he may not have a company in India, he may not have. Please don't do research and tell me that he's having a company and all. I'm sure he may have. Even if he does not have a company, okay, still his mark is protected. That is important for you to understand. Still his trademark is protected. Okay. So we have the story here. A gentleman incorporates a company called Adibas Sports and Leisure Wear Private Limited or Limited as the case may be. Quietly it's done. Now, the lawyers of Adidas, they will have some big shot lawyers who will be having somebody in India also. That Indian lawyer will be constantly watching the trademark registry and the incorporation company name, that also they'll be watching. The company incorporation, that also they'll be watching. To see if any company is being registered with a name that is identical with or too nearly resembling this mark. That is the job of the trademark registry or trademark attorney is called, patent attorney. That is his job. There may be an advocate, company secretary, chartered accountant. You can become a trademark attorney. Means they will pay annually, they'll pay this fellow 5 lakhs. Adidas will pay 5 lakhs, 10 lakhs. For what? Every day he'll get up, one fellow in that office, clerk, he will go to the website, see which are all the companies incorporated today. Whether it is tallying with any of the list of names he has got, resembling anything. Immediately he will blow the Hazar, Adibas. Immediately the lawyer will wake up and then they will inform Adidas. But that will take a little time now. By the time Adidas wakes up, their lawyer comes in US May, then everybody earns money. Then finally, one strong letter will go to the central government, regional director. Whereas our client has got a registered mark, Adidas. Whereas so-and-so company has been incorporated by your office with this name. Whereas my client is prejudiced. Therefore, we request that or we submit that this name should be cancelled. So then the central government will call them for a hearing, regional director, then we'll say what happened, blah, blah. Then central government is of the opinion that the name is identical with or too nearly resembles an existing trademark. Same thing for name also. Suppose another fellow is trying to incorporate Blue Dot, I will wake up and say no, because I have another company called Blue Dot. I have 2 companies with Blue Dot name. Only one company I'm changing it to Prometheus. So if the word Blue Dot corporate solution, Blue Dot training, anywhere fellow comes, immediately I will send a letter to the ROC. Boss, Blue Dot is mine. It so happens Blue Dot is also a registered trademark that I've registered the mark. It is registered in the name of the company, Blue Dot Corporate Solutions. And the whole thing is all registered in my wife's name also. She is also owner of a mark. The point I'm trying to make is, once I convince the CG, then he has to take action. How long do I have to do this? The law will give you 3 years from the date of incorporation or registration or change of name. So for 3 years, you are having time to object. Okay. So the central government can instruct the company to change, rectify the name. This application can be made within 3 years. For trademark, see, this 3 years is common for both. An application may be made by a registered proprietor or the guy within 3 years of incorporation or registration or change of name. The change of name or incorporation could have happened under this law or earlier law, because the law came in 2014, right? So but nowadays it will be only this law. that the name is identical with or too nearly resembles the registered trademark of such proprietor under the Trademarks Act 1999. So 3 years time is given. Within 3 years, the company can be asked to change. So within 3 years, if the central government is of the opinion that's too nearly identical or too nearly resembles, then the central government may direct the company to change its name. Now it's compulsory. Once rectification of name is there, then the central government may direct the company to change its name. Okay, and the company shall change its name. Please note the use of the word shall. Shall means mandatory. Earlier, this section used the word may foolishly. I used to keep on telling it is wrong. Finally, now the new law has corrected that. The company shall change because this is compulsory provision. How it can be may, Baba? Company may change, how we can say shall change its name or new name as the case may be within a period of 3 months from the issue of such direction after adopting an ordinary resolution for the purpose. So for alteration, special resolution. For rectification, ordinary resolution. Okay. So there could be a classic MCQ question where they could say company did this, did that. Now central government has directed the company to change its name. The company shall pass A, ordinary resolution, B, special resolution, C, unanimous resolution, D, none of the above. Like that, they can give you a multiple choice question also. You have to be aware that for rectification of name, it is ordinary resolution. Whereas for alteration of name, voluntarily, it is special resolution. Right? So once the company gets the direction of the central government, it has to hold a meeting and pass a ordinary resolution. Okay. In fact, earlier it used to be may, but see, my dear friends, I'm going to ask you a very logical question. It may sound even a little out of syllabus, but maybe when you come to management and administration, you will understand it better. See, for passing a resolution, members have to come. Then the members have to raise their hand. Ordinary resolution is minimum max. The number of votes cast in favor should be more than the number of votes asked against. Now, I am the company secretary. You are the MD. We have called the meeting. They have all come. We told them, Baba, change the name of the company. All those in favor. Nobody raises the name. Ordinary resolution not passed. What do I do? This question, nobody has the answer. I have been asking this question since 1991. Since 1991, my first public speech on company law at the study circle of the Chartered Accountants, Mr. Arvind Datta's famous Supreme Court advocate was there in the audience. And I asked this question. Suppose they don't pass the resolution, what do I do? I can't force him now. I can't bring up a stick and tell you raise your hand. Because that is a voluntary act. Yeah? He may raise, he may not raise. This is, see, don't think only students can ask question. Faculty can also ask question, which is difficult to answer. There is no answer for this. In fact, my guru, Professor K. Sandraman, used to get very angry with me when I ask a question like this. Because he said, Srikant, don't make the act into a nullity in law. Give effect to the law. Sir, I'm saying I will give effect, sir. I obey the central government. I'm calling the meeting, Baba. But at that meeting, how I can force this fellow to pass a resolution? Resolution is an act of volition. My humble view is a direction should be enough. The board of directors should obey. Something like that. You cannot ask for order resolution for this. That's what I humbly feel. But anyway, the act is, as of now, you have to pass an order resolution. Compulsory. The members are compulsorily, they have to come. Majority number should raise their hand. Why have a voluntary act when it is a mandatory thing? Yeah, you direct the company should change. That's all. A fresh certificate of incorporation should be given to them and say, at best what they can do, they can tell him, please have a choice of name, tell us. If whichever name you want, if it is okay, we will give it to you, proceed. That's all. Okay. I have already warned you not to ask a question on management and administration. I will deal with proxies when we come to that topic. Hitesh, hold your breath till I come to that topic, maybe in June, inshallah, when we will take this topic. At that time, I will talk about proxy. Without knowing what is proxy, you are asking question on proxy. When I come there, I will explain proxy to everybody. then you will yourself get the answer in which resolution proxies can cast vote. I will give the answer. You will have the answer yourself, don't worry. Okay. If it is 6 months, I will verify and get back to you. In the next class, I will check up. If I am wrong, I will correct it. This is exactly the point which I wanted to tell you. Suppose it is 6 months and not 3 months. In which clause? Because tell me the slide number where it is 3 months. Maybe I'm wrong. I could be wrong. But tell me which one it is. Which slide? You tell me. Is it 73? Is it slide 73? You can see the number of the slide here. 73. Okay. If the prospectus has not changed as shown. Madam, when I come to prospectus, you ask this question, preferably in a more clear manner. Okay. My relative, but they had to change the name as Zupi, and Zupi were nearly. Very good. Correct. So you are having a direct example of change in the name. ZUPPI and XUPPI. Joshi, Suyog Joshi. Joshi ji, are you from Gujarat? Okay. Because Bansal telling 6 months, I will check up and I will get back to you. Okay. Vishal Agarwal, again and again and again and again and again and again, I'm telling, I will not do it till Saturday. Can you live with that? Please live with that. Till it is over, I will not upload it. Once this topic is fully over, when the last slide is shown to you, I will upload it. Your request is considered, but it will not be done. I will check up this slide, whether it is 3 years or 6 months. And if it is 6 months, in the next class, I will tell you it is 6 months and confirm it for you. Okay? I have noted your question that you have said that it is 6 months and not 3 years or whatever. I will definitely check up and I will get back to you. Now, notice of change of name is to be given to the ROC together with the order of the central government. Then, are you able to understand? Central government here is the regional director. He gives the notice. Then you pass the resolution. And then the order of the central government and change of name proof and all, you give it to the ROC. Then the ROC will make out the necessary changes in the certificate of incorporation and he will give it to you. Just, it will be similar to alteration ka thing, but except that it will be under rectification of name. So, alteration voluntary, rectification compulsory, right? That is the point you need to understand, right? Chalo, no problem. Now, moving on. I think many students are joining new in this class only. Oh, Josh, okay. Maharashtra, Gujarat, not very far. Wonderful, sir. Wonderful. Good. Nice to know that. Yeah, I will definitely, if there is a error, I will correct it, inform you, and corrected version will be uploaded. Which should also make Mr. Agarwal understand why Srikanth is not interested in uploading in between. Sometimes errors can creep in here. Okay, that is why till the last session I will not upload it. Once the Saturday last lesson will be over, when this topic will be completed in full, then and only then I will upload it. Okay. I have been telling this so many times, but you are asking me, please upload, please upload. And you are merely telling request to please do it is not going to help you. A policy decision has been taken by me and I'm not going to change it for you, for anything. Okay. So live with it. Okay, Agarwal, Vishal Agarwal. Okay. Some things are my control. Yeah. You don't think everything you should control. Okay. You can control one thing. You can control your understanding of the subject. Okay. You can control the way you listen to what I'm saying. Chalo? You can control what you can understand. Okay. That is something you can control. I don't know if I've told you, I'm an All India rank holder in both inter and final, CA and ACS. I'm 4 times All India rank holder. Not to boast, but I'm telling you, it happened not because I kept on demanding things from my teachers. Do this, do that. No, it happened because whatever my teachers told me, I eagerly listened. Whatever I learned from them was good. Balance I learned. So that way my knowledge became triple. What I learned from teacher, what I learned from other people, my own knowledge. And it became very, very thing. That is why I'm telling. Sometimes, don't always have this thing, do this, do that, do this, do this. Srikanth has told, I will give it in the last class. Allow him to do it. No. Be kind, yeah. Be kind to people. Don't be so tough. Give me now, immediately. Don't worry. Chalo. Okay. Suppose you do not comply with the directions. See, what is the direction? Change the name. The CG has sent you a direction to change the name. That is not complied with. Then the company will be liable to a penalty of 1,000 rupees. And every officer who is in default with a fine, it shall not be less than 5,000 rupees, but which may extend to 1 lakh rupees. Okay. So, another question that students generally ask is, actually, there seems to be some confusion because I am putting 3 years. I don't know how I got that 3 years. So maybe to my see in the earlier act, it was only 6 months. In the earlier act, it was 6 months. So you can always wind up and go, Miss Virali, you are at liberty to leave now. You need not worry. You can leave now. Okay. I may go on till 8:20. You can leave now. This is what I used to tell my students in my physical classes. Student is very restless and want to leave the class. And I say, you can go now. But the class will get over whenever I want to close it. Okay. Yeah, 8:20 is what I'm thinking. Because I just need to close the topic and then I will close at 8:20. Normally I give 10 minutes break. That 10 minutes break is going to go at the end. Okay. Is that okay, Ms. Saipa Virali? Sorry if I'm being a little blunt and rude, but sometimes you don't understand. Don't worry. Hardly another 5 minutes. Yeah, what is that? No problem. Thank you very much. CG full form. Central Government. Central Government CG. Regional Director RD. Okay, regional. That's what I told you. Most of the sections where you find the word central government, it is actually regional director. It's actually the regional director, right? So if the company is in default in complying with any direction, the central government shall allot a new name to the company in such manner as may be prescribed. So suppose, I told you now, I asked you a question, right? What did I say? Suppose the resolution is not passed. What do? Now the section 16 says, if there is a default and the resolution is not passed, then the registrar, the central government will allot a new name. Thereupon the registrar will enter the new name in the register and the old name and issue a fresh certificate of recommendation, the new name, which the company shall use thereafter. Okay. Now my only question is, since you are anyway doing this, why are you even asking him to pass a resolution? Why waste? You tell him your name is too nearly resembling. You give him opportunity to give a new name. In case he doesn't give the new name, straight away invoke this provision and change the name is what I would humbly suggest. Okay. Of course, once the central government has given this so-called new name to you, you can always go back under section 13, amend the memorandum. Am I correct? And get another new name. But you cannot get the earlier name. No. The company will not be allowed to change because that was offensive name. That will not be allowed. Right? So, I have at this point in time reached a stage where we have completed 76 slides. In the next class, inshallah, we will finish this topic and I will upload the slides to you. Okay? Don't worry. And what I will do is, I will completely clarify this part. Okay? Because one thing I can assure you, most of my slides are carefully researched. Right. Now, shall we once more understand this? to get the clarity. See, you are the owner of a trademark. A company has been inadvertently or otherwise incorporated with a name which too nearly resembles or is identical with your trademark. When you can object? Within 3 years of incorporation, you can object. Your time for objection is 3 years. Whereas, once you go to the central government accepts there is an identity, then the central government will direct the company, right? Now, from the date of direction, the company shall change its name as the case may be within a period of 3 months. This 3 months, whether it is 3 months or 6 months, I will definitely clarify it in the next class, not today. Okay. We also have Prabhas Jain saying 3 years is correct, but the students are confused with company. It was 6 months earlier. It has been substituted with 3 months by Act 29 of 2020. That is why I said most of the stuff given in my notes is correct. But when students in a public forum are objecting, I will not argue. Like Ravana, I will come back tomorrow. And like Lord Rama, you should also say, I will give you one more day, take it, because you are all Ram. I am only Ravan. Even Ram was willing to give Ravan 1 day's time. I mean, get it? In the middle of the battle, Ravan was standing Nirayada Bhani. At that time, Ram said, don't fight today, go back, come tomorrow. So that opportunity should be given to the faculty. Na? So allow me to go Nirayada Bhani today. Tomorrow I'll come again to fight with the data. Okay. Somebody was asking who is Prometheus. What is Prometheus? Prometheus is a Greek god. In fact, he preceded even the gods. Prometheus was even before the gods. He was a titan. Prometheus was the person who brought fire to the world. See, the fire was originally only with the gods in Greece. In the pantheon, the gods only had fire. Human beings had no fire. So in the night, they used to work either by the full moon and all. During new moon day, they will hide because it's dark from the animals and all. But for the first time, Prometheus stole the fire from the gods and he brought it to the world and he gave it to man. So that is why Prometheus is great. And Prometheus is a symbol of knowledge. Prometheus is a symbol of the light of knowledge, which once Prometheus brought fire to the mankind, the progress of mankind started. They started making brass tools. They started making iron. They started smelting metals. They made the wheel, and that's it. Everything started. So the gods were very angry with Prometheus, and they punished him also. How they punished him and all, you read it in the web. How the gods punished Prometheus, very, very brutal punishment they gave to Prometheus for bringing fire to mankind. But that's not a problem. Okay, Prometheus is one of my role models because every one of us should bring fire of knowledge to the world. So, Tamasoma Jyotirgamaya. Tamasoma Jyotirgamaya. From darkness to light. Asatoma Sadgamaya. Tamasoma Jyotirgamaya. Mrityorma Amritangamaya. Okay. So, with these words, we will close this session and wishing you all a very great weekend ahead. Of course, weekend is still far away. Saturday again we will meet when, inshallah, we will finish this topic. Good night. Bye.